Hello, everyone. In this lecture, we're going to be covering, and I believe this is lecture number 6, we're covering federalism, which is a discussion of the relationship between the federal government and the states. If you recall, when we uh, started out as a country, we had what is called a confederacy. And what I think I would like to do is uh, explain the various forms of government. Um, Confederacy is a loose affiliation of uh, related states. Uh, and the Confederacy is very uncommon form of government. The most common form of government is a unitary form of government. In a unitary form of government, you have a single agency, which is the government, uh, regulating the entire country. Every state in the United States has a unitary form of government. Most countries in the world have unitary forms of government. France has a unitary form of government. China has a unitary form of government. Uh, in our country, we started out as a confederacy, but we quickly determined that the confederacy was not going to was probably going to fail. And in order to avoid that failure, we had a meeting where we modified or amended or actually drafted a new uh, constitution. And that's the constitution that we operate under now, which is a federal system. In the federal system, there are certain powers that the federal government retains. There are certain powers which are shared between the federal government and the states, and there are certain powers which are generally left up to the states. Although as time goes by, there's more and more of those individual powers left to the states are subsumed by the federal government. What I propose to do in this lecture is to track the growth of the federal government from the very beginnings, 1789, when our government, the federal government, was fairly weak, until the present day, when the federal government has grown and grown in power. Uh, Under the original uh, form, we have what's called um, cooperative. Well, there's two forms of federalism which we will discuss. There's dual federalism, and then there's cooperative federalism. Dual federalism is where the two governments, the federal and the state government, have clearly defined functions. Cooperative federalism, which is more the modern uh, uh, system that we operate under, is where there is a bit more of the federal government reaching into the states and directing the states as to how to behave. Uh, the change from dual federalism to cooperative federalism occurred along about 1937, and as we'll see when we go through the Supreme Court cases to illustrate the growth in power, you'll see what I mean when I say that 1937 is generally considered to be the date when dual federalism ended and cooperative federalism began. So first of all, let's start with why we've recently had some severe storms, hurricanes here in Florida, and there was much complaining that the Federal Emergency Management Agency, FEMA, was not acting quickly enough to respond to this local disaster. And I guess the question that I usually ask when we discuss this is, why are we, the state of Florida, why are we expecting that the federal government should step in and assist us in what is clearly a problem that only affects Florida? And very often when I ask that question, somebody in the class will suggest, well, it's because we pay taxes to the federal government. And that's a good answer. We certainly do expect to get something back from the tax money that we spend. But there is another answer, and that is we live in an era of cooperative federalism rather than dual federalism. When the federal government first started out, here's what James Madison wrote in Federalist number, let me see if I can pull it up here. Federalist number 45. We've talked about the Federalist Papers before, and here is from Madison in Federalist Paper number 45. He's talking about the nature of the power that this new federal government, and he's trying to reassure everybody that the federal government is going to have limited powers. And here we start here. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects, and we're talking about the federal government, external objects such as war, peace, negotiation, and foreign commerce, with the power of taxation will for the most part be connected. So is that how our government works? Is that how our federal government? No, not really. Initially, yes, that was the hope. And I think that Thomas Jefferson, who was the strongest proponent of this idea that the majority of powers should be left to the states. Don't understand this. The Confederacy that we started out with was Jefferson's dream. That way that under the Confederacy, the states had the majority of power, and that's the way that Jefferson saw that it should be. And he was quite concerned that this new federal government came into being while he was in Paris. But what I want to do is let's talk about some cases. First, I want to, and this one directly relates to Thomas Jefferson. I want to talk first about a case called Marbury versus Madison. Now, in order to explain Marbury versus Madison, I have to show you a federal statute. Let's see if I can pull it up here. All right, here's this federal statute, and this was passed. This is the Judiciary Act of 1789, and it's important to see this because it's relevant to Marbury versus Madison. Now you can see that this is the Judiciary Act, September 24th, 1789. Within about 6 months of Congress's first meeting, they passed this law, which was to establish the judicial courts of the United States. And in it, under Section 13, it talks about what the powers of the Supreme Court are to be. Now, if you remember, under the original Constitution, the primary power of the Supreme Court was to be appellate, which means that they were only going to review cases that had been decided by lower courts. It was not to be a court of original jurisdiction, meaning that's where you would start with your lawsuit. It was not to be a court of original jurisdiction except in very, very limited circumstances. But here, the Congress said that the Supreme Court shall also have, it talks about appellate jurisdiction, and shall have, this is the important part, and shall have power to issue writs of prohibition to the district courts, which is an order directing a lower court to stop doing something, and writs of mandamus, which is a court order directing usually a public official to do their job, to do something that they are supposed to be doing but are not. So the Congress gives to the Supreme Court this new power, the power to issue writs of prohibition to stop lower courts and issue a writ of mandamus, which is to require people who are holding office under the authority of the United States to do something that they're supposed to be doing. Now, in Marbury versus Madison, we have to discuss briefly John Adams. Now, we have mentioned that John Adams was a member of the Federalist Party, and the idea behind the Federalist Party was to try to make the federal government as powerful as possible. Both Madison and Jefferson opposed this idea, but Hamilton and Adams were members of the Federalist Party. Jefferson and Madison were members of the opposing political party, which at various times, well, primarily Jefferson referred to this party as either the Anti-Federalist Party or the, don't get confused by this, the Democratic Republicans. This party has really got nothing to do with the modern political parties of Democrats and Republicans because the issues are very different from what they are today. But John Adams, he only served one term, and he was not pleased that he only got to serve one term. He thought that he should have served at least two, just like George Washington did before him. And when he lost the election, he began to fill up the federal courts with judges. It was to his benefit. Congress had passed another law increasing the size of the federal judiciary, and John Adams took full advantage of this by filling up as many judge positions as he could with members of the political party that he was a member of. You know, many years ago, some of you might know that I worked for the Office of the Attorney General here in the state of Florida. And one of the things that the Attorney General does is in Florida, we have a kind of an odd government where the Attorney General and the governor and some other individuals work as a team to govern Florida. So we have sort of a group of people who are in charge of Florida rather than a single strong governor. Anyways, many years ago, a friend of mine had, in order to become a judge, one of the ways you can become a judge in Florida is when a position opens up, you can apply. And a committee called the Judicial Qualifications Committee reviews all the applications and selects the top three. And by good fortune, a friend of mine happened to make it into the top three. And so he contacted me and asked if I would be willing to write a letter of recommendation to the Attorney General, who would be, you know, my boss's boss. I said, let me check with my immediate supervisor, and if my supervisor says it's okay, sure, I'd be happy to write a letter. So I went down to talk to my bureau chief and laid it out. Said, you know, this my friend is in the top cut. Is there any reason that you can think of where I should not write a letter of recommendation? And the very first thing out of my boss's mouth was, "What political party is your friend?" Which kind of surprised me, but it really shouldn't have, because if you pay attention to the appointments that in recent times that Mr. Biden and then Mr. Trump and some other recent presidents, Obama as well, the appointments that they made, they fit very well with their political party. Mr. Trump appointed extremely conservative people to the federal courts when he had the opportunity. And Obama and Biden both appointed fairly liberal individuals to the courts when they had the opportunity. And so John Adams was doing exactly the same thing in 1800 when he was voted out of office, but he still had a few months to go before his term ended. One of the people that he appointed to a federal justice of the peace position in Washington, D.C. was a fellow named William Marbury. John Adams wrote a letter to William Marbury saying, "I've appointed you to a position, so come to Washington, D.C. and collect your commission as soon as you can." Well, Marbury was delayed in getting there. I mean, we're talking about, early 1800s. And transportation is slow. Marbury had to close up his law office and somehow make it to Washington, D.C. And by the time he did get to Washington, D.C., John Adams had already left, and now there was a new president, Thomas Jefferson, in office. And as I mentioned a minute ago, Thomas Jefferson was not a friend of the Federalist Party. So you have to imagine the scene. William Marbury arrives in Washington, D.C. There's a new president in the White House, and he goes to the White House, knocks on the door, and James Madison comes to the door. And Marbury says, "I'm here to pick up my commission for Justice of the Peace." And Madison looks puzzled for a minute and then says, "Wait here," shuts the door. Minutes go by. Madison comes back and he says, "We have no commission for you here. Go away." Well, Marbury has a letter from John Adams as proof that he was supposed to receive the commission, and it's apparent to him that the Jefferson administration has decided to dispose of his commission rather than to allow him to take the position. You should remember that most federal judge positions are for life. So by appointing as many judges as he could before his term of office ended, Adams was doing the best that he could to damage Thomas Jefferson's ability to get anything done. So when Jefferson and James Madison had the opportunity to block William Marbury, they did so. Well, Marbury, being an attorney, felt that he was being wronged, and looking back at the Judiciary Act of 1789, which purports to give the U.S. Supreme Court the power to issue a writ of mandamus, William Marbury files a petition in the U.S. Supreme Court asking the court to issue a writ of mandamus directing James Madison and effectively the Jefferson administration to turn over his judicial commission. Now, you also need to know that the chief judge of the Supreme Court was a fellow named John Marshall. John Marshall was one of the judges that John Adams had appointed. So he was a Federalist. And three of the cases that we're going to be looking at in this lecture are all cases that were decided by the Marshall Court. And I've often said that one of the ways that you can explain the ruling of the Marshall Court is whatever Marshall does, it makes the federal government more powerful, either the Supreme Court or the executive branch. Makes them more powerful every time. So when William Marbury comes before the Marshall Court asking for a writ of mandamus directing, getting a court order from the Supreme Court to tell the Jefferson administration to do something, one of the things that John Marshall is very concerned about is if he issues the order, and it seems clear. I mean, they had a little trial, and they had witnesses, and William Marbury testified, and in the opinion, let me pull up the opinion here so you can take a look at it with me. Here's Marbury versus Madison, which you can see was decided in 1803. One of the things that John Marshall was concerned about was, well, if I issue this writ of mandamus, Thomas Jefferson might just ignore it. And that would be the worst thing that could happen to the U.S. Supreme Court, that the executive branch would, in the early days of this new country, would see fit to completely ignore a court order from the Supreme Court. It's interesting to remember that the Supreme Court really doesn't have any enforcement mechanism. When they say that you should do something, we obey them out of respect. But there have been many occasions where the obeying was delayed considerably. For example, when the Brown versus Board of Education was decided in 1955. The stated purpose of the Brown versus Board of Education decision was that public schools should no longer be segregated, but should be integrated. And in 1956, when the court was asked, Well, how soon should this occur? The court responded, with all deliberate speed. Well, I can tell you that 15 years later, I was just out of elementary school, I believe, and I was still attending white-only schools. So the idea that we obey the Supreme Court out of respect, not always. We don't always obey them, and we don't all. When we do obey them, it's not always quickly. That was what John Marshall was concerned about in Marbury, was that he would issue an order that the court could not enforce. So what he did instead was, look, he says, I don't want to create a ruling here that's going to make the Supreme Court look weak. So instead what he did was he looked at Article 3 of the Constitution, which spells out what the Supreme Court has the authority to do. And if we take a look at that, which I have right here, scroll down to Article 3 and we'll take a look. Here's Article 3. Now, if you look through it, it says that Section 1 just talks about the essence of the Supreme Court and the court system, the federal court system. Section 2 talks about what the powers are of the Supreme Court, and specifically limiting nowhere in here. I mean, it limits the Supreme Court to appellate jurisdiction, and that's other than cases affecting ambassadors, public ministers, and consuls, and those in which a state shall be a party. There the court has original jurisdiction, but in all other cases, the court has appellate jurisdiction only. So John Marshall looks at that, and then he looks at the Judiciary Act of 1789, and he sees that there is a conflict here. The court, under the Constitution, has no authority to issue a writ of mandamus, and that's where John Marshall goes with this. Instead of telling Thomas Jefferson, give the man his commission, John Marshall concludes that William Marbury is entitled to have his commission. Unfortunately, he says, the Judiciary Act of 1789, which purports to give this court the authority to issue a writ of mandamus, unfortunately, that subsection of the Judiciary Act is unconstitutional because it's not supported by what Article 3 says. So in doing so, John Marshall makes the Supreme Court more powerful by announcing this new rule, a rule of judicial review, which it sounds like it's more than what it actually is. But the power of judicial review is not just we're going to take a look at what lower courts have done. It's a term of art specifically referring to we're going to look to see if what the lower court did is constitutional, if it complies with the Constitution, or if what the executive branch done is constitutional, or what the legislation purports to attempt to accomplish, whether that is constitutional. That's the power of judicial review, and that's what was announced in Marbury versus Madison. So, all right. The next case is a case called McCulloch versus Maryland. And let me pull that up here. Now, in McCulloch, we are looking at the National Bank. Now, if you remember when we talked about Alexander Hamilton, one of the things that he wanted to do was to create a new national bank. He felt that the national bank would give the federal government more power, make it easier to do some of the things that he wanted to do with the federal government, including the paying off of the Revolutionary War soldiers who had never been paid by their states. He wanted the federal government to pay off that war debt. And so this national bank became a thing. It came into existence. And it announced that it was going to be opening up a branch in Maryland. And well, think about this. How do banks, most banks, make their money? They do it by you going in and borrowing money from them and then paying back that money with interest. The interest that the bank charges is how they make money, make make a profit. If the federal government opens up a branch in Maryland, Maryland saw pretty quickly that they would be in competition with the national bank, and they didn't want their local banks to fail. There's enough competition there already. So the national banks announced that, well, if you're going to open up a branch here in Maryland, we're going to impose a tax on you because we want there to level the playing field so that you won't be able to undercut local banks. Well, the national bank, who was being operated by a fellow named McCulloch, refused to do that and filed suit against the state of Maryland. And Maryland posed the following questions. First, is it constitutional for the federal government to create a bank? And secondly, is it also permissible for Maryland to impose a tax on the national bank to, as I said, level the playing field? So turning to the first question, again, we're in John Marshall's court. What John Marshall does is he looks, and the question is it constitutional for the federal government to create a bank? Marshall looks at the Constitution, so we will too. And we have to look at Article 1, Section 8. Here is Article 1, Section 8. These are all of the express powers of Congress. Now, if you remember, the U.S. Supreme Court's ruling in Marbury versus Madison was, if it's not stated in the Constitution, then it is not constitutional. And that's the very argument that Maryland made. Nowhere in here does it say Congress shall have the power to create a bank. But remember, John Marshall wants the federal government to be more powerful. So if he can find a way to authorize a national bank, he's going to do it. And this is how he does it. He goes down here to the very last clause here, which is called the necessary and proper clause, also known as the elastic clause, because it allows the government to stretch some of these things in order to justify its action. And this is what John Marshall does, is he says some of these things at the top here, laying taxes, collecting taxes, duties, imposts, excises, and paying debts, all of those are bank-like things. And having a bank would make it easier, would facilitate the exercise of those duties. So John Marshall says that under the combination of the necessary and proper clause plus the first few of these clauses in Article 1, Section 8, we do find, the court says, we do find that it is constitutional for Congress to create a bank. All right, so turning to the second question, is it permissible for the state of Maryland to tax the national bank in order to level the playing field? John Marshall quickly, puts that to rest. The power to tax, he says, is the power to destroy. It would not be reasonable for me to conclude on the one hand that Congress has the power to create the national bank while at the same time also giving Maryland the power to destroy it. So to answer those questions, is it constitutional to create a bank? Yes. Is it also constitutional to allow Maryland to tax that bank? No. So remember, the federal government is going to come out on top when John Marshall is on the bench. The next case that we're going to look at is interprets the Commerce Clause, and that Gibbons versus Ogden. We pull this one up. This is the case of Gibbons versus Ogden. You see it was decided in 1824, and John Marshall Court, he is still on the bench after 20 years. And in this case, Ogden has a New York, an exclusive license to operate a commercial ferry boat service in the state of New York. And Gibbons has a federal coasting license that allows him, excuse me, that he's been using to transfer to ship passengers and cargo between New Jersey and the state of New York. Ogden feels that that's imposing on his exclusive right to the trade in New York, and so Gibbons files a suit against Ogden. Now, if you have to predict, knowing that it is a John Marshall decision, who is going to win? The guy that has a federal coasting license or the guy that has the state exclusive state license? I think you can predict all along the federal coasting license is going to win. And what John Marshall does is he looks at Article 1, Section 8. Sorry about that. Article 1, Section 8. And it says that Congress has the power to regulate both interstate and international commerce. This is clearly within the confines of that. And so does Gibbons' federal coasting license authorize him to transport passengers and cargo into the state of New York? Yes, it does. May the state of New York prevent him from doing that? No, they may not. So those are three cases that over the course of the early years of the United States gradually increased the power of the federal government. And we're still operating under what we refer to as dual federalism. Sometimes, if you take the image of a layer cake, they sometimes also, believe it or not, they refer to it as layer cake federalism, because the federal government is on the top layer in this layer cake, and the states are all under the federal government in the lower level. And as a general rule, in dual federalism, the federal government only operates within certain limited things. Very rarely does the federal government to reach out into the states to tell the states what to do. That changed, though, during the years of the Great Depression. Now, as many of you know, the Great Depression began in 1929 when the stock market crashed. I don't think that you can say that the stock market crash caused the Depression, but it was a symptom of the Depression. At the time Herbert Hoover was president, the town of Washington, D.C. was still fairly small. And one of the things that was kind of a hallmark of the Hoover presidency was he was a strong believer in the dual federalism model. If the states are having economic crisis, that's up to the states to fix that problem. The federal government has no responsibility to try to sort out economic problems that the states are having. There was, in fact, something that happened right at the end of Hoover's term of office. You know, we fought in World War I, and when World War I was over and Germany was defeated, Congress voted to give the veterans of World War I a bonus, and that this bonus would be given to them some years in the future. Exactly why Congress decided not to give it to them right away, but to give it to them years after World War I ended, I'm not really privy to that information, but that's what they did. And a number of these World War I veterans, quite a number, 25,000 of them, in fact, got together and came to Washington, D.C. with the idea that they would perhaps be able to put some pressure on Congress. We need the money now. We don't need it 10 years in the future. We need it now. Congress wasn't prepared to do that. And Hoover, not only did he, I mean, if Hoover had been doing the right thing, he would have gone out and talked to the veterans and made some kind of at least some kind of token gesture. But what Hoover's notion was, these are not veterans. These guys are hooligans. And so he called out the National Guard and they gave him the bum's rush out of Washington, D.C. Some of them were shot and killed. So it was a needless to say, Hoover did not win re-election after that. The next person to become president was Franklin Delano Roosevelt, who prior to being president was the governor of New York, and he had some hands-on experience with soup kitchens and that kind of thing, because New York was under the same depression as was the rest of the country. Roosevelt began to quickly take actions to try to stem the worst effects of the Great Depression. One of them was the persistence of bank failures. People see, at the time, the federal government did not guarantee funds in local banks, state banks. And if people got lost confidence in their bank, they might try to run to the bank and pull their money out. And as you might already know, if in most banks, if you deposit money into the bank, what the bank does is they have a certain amount of capital on hand, but the balance of it may be loaned out. So if everybody tried to go and pull their money out of a bank, the bank might not be able to satisfy all of those funds, not right away. So in those cases, the bank would close, go bankrupt, in other words. What Franklin Roosevelt did was he called for a bank holiday to kind of cool things off. And then he began setting up different agencies to try to help regulate the economy. He's created the Agricultural Adjustment Administration to try to help stabilize farm prices. One of the ways that they do that is they sometimes will pay farmers not to grow anything. I mean, there are times when a field needs to lay fallow to recover, but also if all the farmers plant the same crop, then the market value of that crop is going to go down. So the Agricultural Adjustment Administration was intended to help manage the crops that farmers are going to grow, so that it stabilizes the prices. Franklin Roosevelt worked to repeal prohibition, which he finally did in 1933. He set up federal agencies that put people to work, the Tennessee Valley Authority, for example, and the Works Progress Administration, just to give people who could pick up a shovel, just give them something to do so they could earn some money. At the depths of the Great Depression, 25% of all households were out of work. It had been out of work for years. And when I say that, you have to remember that this was a time period when women traditionally did not work. So 25% meant a lot more than what it would today, because women generally did not work. So Roosevelt, in setting all of this up, was trying to address some of those immediate problems. The next thing that he did was he created the National Industrial Recovery Administration, which was intended to that all companies would have to set a minimum wage of between 20 and 40 cents per hour. Can you imagine? Earning 20 to 40%, 20 to 40 cents per hour. But we have to keep in mind it's we're talking 1933, and also setting a maximum work week of no more than 40 hours per week, and also to eliminate child labor. Well, this met with a good deal of opposition, and in the next case, which we're looking at, it's called, well, let me pull it up here and we'll look at it. Schechter Poultry Corporation versus the United States. This was decided in 1935, and in this case, the Schechter Poultry argued that the Roosevelt administration did not have the constitutional authority to tell a local company what to do. They had no authority to create minimum wages, no authority to tell them that they couldn't hire children to work, and no authority to tell them how many hours was the maximum work week. And to Franklin Roosevelt's great disgust, the U.S. Supreme Court agreed and struck down the National Industrial Recovery Administration. Roosevelt was so upset that he actively began pushing the notion of increasing the size of the Supreme Court. Congress has the authority to increase the number of justices. And his idea was that if he enlarged the size of the Supreme Court, he would then be able to appoint his own people on the Supreme Court. And maybe that would allow him to get some of his bills through the court. This was working its way through Congress, and honestly, I don't think that it had that much of an impact on what the court did next. I think really what did work was Roosevelt became wiser about how to go about drafting legislation so that it would be constitutional. His next challenge in the Supreme Court was a case called National Labor Relations Board versus Jones and Laughlin Steel. And let's pull that up. In this case, Roosevelt created this labor relations board, and the idea was that these people would go into some companies, large companies, and help them set up labor unions. Now, if you're the owner of a steel mill and you've got the federal government coming in helping your employees to organize, you're not going to be pleased about that. And certainly Jones and Laughlin Steel was not pleased. So they filed suit. This time, however, I'll show you the case. National Labor Relations Board versus Jones and Laughlin Steel. You see, this was decided in 1937. And this is the case that marks the beginning of cooperative federalism. In this case, the U.S. Supreme Court found that because Jones and Laughlin Steel was selling its steel nationwide under the Commerce Clause, the Roosevelt administration did have the authority to work to regulate how this company did its business. And like I said, I think Roosevelt just got smarter about the way that he was drafting the legislation that he got Congress to pass. But in any event, once he figured out how to use the Commerce Clause to regulate local businesses, he did all kinds of things following that. There's the FDIC, which guarantees bank deposits. There's Social Security. I should also point out that in the context of Social Security, that Franklin Roosevelt was under tremendous pressure by his critics. One of them was Huey Long, and there was a number of groups that felt that American capitalism was no longer working. And partly this was due to the fact that Russia claimed that they were not suffering from any depression at all. They had a managed economy, and there was Great Depression is something that happens to capitalists. It does not happen to Russia. Well, some people were foolish enough to believe that. And so they began putting pressure on Roosevelt to adopt some of these programs. And Social Security is actually one of those programs that he adopted in response to some of the pressure that he got from pro-socialist groups. Now, when I say Social Security is a socialist thing, this is not intended to be a criticism of it. It's merely a description of what it does. And when I say that it is a socialist program, what I mean by that is a socialist program takes money from people who have it and transfers it to people who need it. I remember when I first began working and I got a paycheck and I saw that there was something, some of it was taken out for income tax, and then there was something that was taken out for something else entirely. And I asked somebody, what is this? Oh, they said, oh, that's Social Security. Don't worry about that. You'll get it back. And I naively thought that what was happening was that the federal government was taking money out for Social Security and sticking it into a bank account for me, and then when I retire, I'll be able to access that money. No, that's not how it works. Instead, all the money that we put into Social Security is immediately sent back out to the retirees and the people who are on disability and other sources that are entitled to get some kind of money from the Social Security Administration. As I said, Huey Long had this argument that nobody needs to have more than $8 million. And what we would do is let's put a 100% tax on anything over $8 million. And then we'll have this, what he called the share the wealth society. Every man will be a king. Franklin Roosevelt honestly did feel some strong pressure from Huey Long and his group. But unfortunately, Mr. Long was assassinated by a critic in 1935. The impact of the Great Depression is and Franklin Roosevelt's responses to it are still being felt today. We still have Social Security. We still have food stamps, unemployment compensation, agricultural subsidies, all started by the Roosevelt administration and all still with us today. It's more and more what I'm talking about when I say that the federal government has figured out ways to regulate our behavior by looking at certain specific areas and putting pressure on those areas. So they encourage farmers to grow certain crops while discouraging them from growing others. They use the federal money to influence our behavior. Now, one way that they do this is through grants. The two basic types of grant, there's categorical grants and there's block grants. Categorical grants used to be a lot more favored, but they're fewer and fewer things are being operated as categorical grants. And a categorical grant, a good example of that is Medicaid. The federal government gives money to the states to fund Medicaid, which is basically health insurance for the poor. And when the state uses this money, they have to document that they have used it for the money, for the purpose that the money was sent to them. So that's why states really don't, they would rather not, they don't favor categorical or conditional grants as much because it's there's a lot of paperwork involved. Food stamps, Medicaid, as I said, and sometimes, Head Start. Sometimes the federal government will create a categorical or conditional grant that requires that the state produce matching funds. So yeah, those are they still exist, but the trend lately is to move more towards block grants, which are easier to administer. A block grant will send money to a state for a purpose, but doesn't really require that the state strongly document that the money was in fact used for that purpose. Just you have to spend it to fix your roads, for example. Spend the money on things like counterterrorism or housing for the poor. Those kinds of things are typical of block grants. Now, the last thing I want to talk about is unfunded mandates. States hate unfunded mandates because, as they say, they are unfunded, but they are still things that the states are required to comply with. The first of these is the Americans with Disabilities Act, which began, 34 years ago in 1990. This is a direct order requiring businesses of all types to modify their businesses to make them accessible to people who are handicapped in some way. Mayor Koch of New York City famously said that it would be cheaper to buy everyone in New York City cab fare for life than install all the wheelchair ramps that the ADA required them to build. So yeah, every semester, I will get a letter from the compliance division at HCC, which will identify a student as requiring certain accommodations. They don't tell me what the disability is. They just say that this student requires preferential seating or perhaps assistance with taking notes, that kind of thing. And I always comply with it. But that's a typical example of an unfunded mandate. Another example that works in a different area is the drinking age. Now, currently, you have to be at least 21 years of age to get it to buy alcohol legally, and this is true throughout the entire United States. And the way that they manage this used to be that the drinking age was 18, but then um, a lobbying group called Mothers Against Drug Driving got together and began putting pressure on Congress to raise the drinking age because, in their opinion, and this is possibly true, people who are 18 don't have good enough judgment as to whether they're in a shape to drive after they've been drinking. So what Congress did was they didn't have any authority to directly tell the states, raise the drinking age. Instead, what they did was they used something called a crossover sanction. They said, we're not going to give you any money for your highways unless you raise the drinking age to 21. So some states held out, but within a few years, every single state in the country had raised the drinking age to 21 so that they could get highway funds to repair the roads. Finally, we have the Environmental Protection Agency, which came into being under Richard Nixon in the 1970s. This directs the states to fix environmental problems, and sometimes it's the state that's required to do it. Sometimes it's an individual corporation that's required to do it by imposing fines for failing to comply with EPA guidelines. If you take a look at what are called Superfund sites, there are areas within Hillsborough and Pinellas County that have been designated as Superfund sites. And what that means is that they are so polluted that the EPA regularly monitors them and limits the kind of activity that can be the kind of business that they can be involved in because of the pollution that's created by some previous business. All right, so that's my discussion on federalism, and that's how we got from dual federalism to cooperative federalism. Thank you for your attention, and we'll see you at the next lecture.